started. We have formed a quorum, and it's time to start our meeting. Please invite the guests to join us.
Welcome. Okay, thank you, representatives of the Law Society, for coming. I think we all know each other, so there's no need for introductions. Before we allow members to ask questions, would you like to add anything to the papers and the rules that has been tabled at LegCo?
Mr. Chairman, thank you for inviting us to attend this panel discussion. Right? I don't think we have got anything to add, but of course we are here to answer any questions that your members may have. But for this information of this panel, right, the Law Society Council has considered implementing the LLP, right, as soon as practicable, and we're aiming for the commencement day, hopefully first day of January 2016.
Great.
So it's very crucial that we get all the subsidiary legislation to be clear completely. We understand that the Order 81, or the rules of the High Court and the rules of District Court, is going to be amended in due course. It's going to be gazetted very soon.
Yes, I've read your letter dated the 29th of June 2015 to this panel. It's a LegCo paper CB4-126801. But I think we have some queries about what exactly is the status of Order 81. Is it now before the Chief Justice or what?
This is, they have been sent to the Rules Committee by the Department of Justice for signing, and after they've been signed, they will be passed back to the DOJ to arrange for Gazette.
When will that take place?
We've been informed that because we've got representatives on the Rules Committee, and we've been informed that the rules have been signed.
Okay, so it's just a matter of formality that they be gazetted as soon as possible.
That's right, yeah.
Okay, all right. 委員有冇咩問題啊？
Questions from members?
或者我問先啊。
Maybe I should start first.
Directly, there are no direct questions on these arising from these rules or papers, but I have been receiving a lot of comments and perhaps complaints from members of the legal profession regarding the arrangement for insurance, especially the professional indemnity insurance issue, that every year they've been asked to make a very substantial payment by way of premium or otherwise. And I understand the Law Society or the PIS has been giving substantial discount, 1/3 discount to members, but it is my duty to relay the concerns of the members of the profession and to ask that the Law Society do consider whether there is sufficient funds in the surplus right now. I think the current surplus is $2.1 billion, and whether that is enough to justify a further reduction of insurance payment by members of the legal profession, because it is a big payment, especially for smaller firms and practitioners, individual practitioners. So I hope to relay this concern to the Law Society. I know this is not exactly the occasion to talk about insurance, but since we are dealing with limited liability partnership top-up insurance rules, perhaps I'll raise that issue with you.
Yeah, I mean, if I could just briefly reply to that, and certainly it's something which will be noted and passed on to the Law Society Council. Just going back a few years, just for the information of members, I think it's as recent as the year 2000 that the fund itself was effectively bankrupt, because we had a lot of large claims, two very, very large conveyancing claims in particular, and also due to the fact that one of the reinsurers of the scheme went bankrupt in 1998. And at that time, we actually were forced to make a call upon the members, because the fund, which is a statutory scheme, as you're aware, requires fixed payments to be made in accordance with the mechanism of the scheme. But in addition, we had to exercise our power, and as far as I'm aware, it's the only time in history we ever did that, to make a further call upon members. And I think because of that, we've been extremely prudent, because there was a strong desire to make sure that that would never have to happen again. And through very, very careful management of the scheme, through our appointed fund managers and through the corporation directors, we have arrived at a situation now where we do have a considerable surplus. That has allowed us, due to an amendment in the rules which took place just before the retirement of the last Chief Justice, which gave us the power for the first time to make reductions. And the issue is considered on an annual basis by the Law Society Council when it comes to time for calling for payments. 4 out of the last 5 years we've been able to grant a 33 1/3% reduction. And we do, I can assure you, take on board the comments of the managers and the recommendations of the fund managers as to exactly what what should be done with the surplus, and what kind of surplus we do need to ensure that we would never have to make that call upon the members again. And with continued prudent management in the future, it is not impossible that we would see even bigger reductions to the premiums which are levied in the future, based if the Law Society correctly exercises discretion. We're aware that for smaller firms it is a considerable sum. We are, of course, the only profession that has to carry compulsory insurance. None of the other professions have it imposed upon them by the legislature. So we are fairly unique in that regard. It does amount to a considerable contribution, but one also has to bear in mind that the welfare of the public is being protected here by the contributions to the scheme. Based on personal experience, I can say that probably on average it cost about $60,000 for a contribution for a firm with a clear claims record, which, if one breaks that down to, say, $5,000 per month, it is not an enormous sum for the solicitors to bear, so that the public can be adequately protected.
Thank you for those comments. I look forward to seeing further reductions, if possible, given the surplus you have now. Let me find you.
Hi, Miss Priscilla Leung. Yeah. I thank you for attending the meeting.
No, it's not coming through.
Testing.
Testing. Can you hear? Testing. This is the English channel. We know that this committee is talking about legal services rules. We all wear 2 hats. All 3 of us are legal professionals, and we also consider public interest. So I would like to be clear. Now, in this amendment legislation, it's clear that if certain conditions are met, then any partner who is innocent will not have to, as a result of misconduct by other partners, bear personal legal responsibility. Now, that's an important point. So would you please make clear certain conditions? What are those circumstances that would qualify as those certain conditions? We have to consider clients' interests. Can you be more clear? What are those certain conditions? I thank Ms. Leung for her question. Now, the first question, certain conditions. In the future, any law firm, if they want to be an LLP firm, they must post the wording LLP, and they also have to purchase top-up insurance, professional indemnity, $10 million per claim. So in these two respects, the consumer's rights will be protected. He can go to an LLP law firm, and he will benefit from the top-up insurance, additional $10 million. Now, as for certain conditions that by which an innocent partner can be can avoid other legal responsibility. Now, that is in the legal practitioners amendment ordinance that is stated there. Now, it doesn't mean that an innocent partner can stay clear. You have to prove that you have taken reasonable steps to monitor how matters are dealt with in the law firm. You have to do due diligence before you can be exempted from the responsibility. Now, to set up a law firm, one has to bear these responsibilities. So, if a consumer suffers a loss as a result of negligence, he will claim from the law firm, and at first there's a PIS cover, $10 million with LLP top-up insurance, additional $10 million. Now, that's the most basic. It's almost $20 million per claim. Looking at the past, the historical claim figures, now several years ago we came to LegCo. We showed the figures, but I don't happen to have these figures on hand today. In most cases, the claims, over 90% are less than $10 million per claim. Now we're going into the LLP. We have to give additional confidence to the consumers, so that's why we have top-up insurance, so that we are in line with Singapore and London and other jurisdictions. Now, on legal liability, we have civil and criminal liabilities. Now, on civil liability, now, how are you going to have due diligence? Now, you have examined the mechanism within the law firm, probably. Now, to reduce the vicarious liability, do you have something that the partners have to bear? That's civil. Now, on criminal, now I know one partner who took the client's deposits to buy a real estate, piece of real estate, and he lost the money, and partner has to go to jail, and there was a long litigation, and the person got clear. Now, are there certain conditions under which the so-called innocent partner does not have to bear criminal liability, or even in civil liability, he also is able to avoid that. Now, there's both civil and criminal. Now, these are important issues. Now, on criminal liability, now this is basically individual behavior. If a certain partner has committed a criminal offense, he stole the client's money or other criminal offense, then he personally has to bear the criminal liability. Now, the criminal liability cannot be extended to other partners unless the other partners were also involved in some sort of conspiracy in the worst case. Now, if indeed there was conspiracy, it's more than one partner, then the other members would also bear criminal liability. But by and large, if it's a personal criminal liability event, then that partner bears the criminal liability. The others who are innocent, who did not take part in the crime, do not bear any criminal liability. That's my view. Now, on civil liability, now previously we know that for an general partner, in a general partnership, no matter how innocent you are, you will be jointly and severally liable overall. So that's why we have introduced the LLP. So if an innocent partner is indeed free of any fault, then he doesn't have to bear the liability of the civil negligence of the other partner. Now, if the other partner is negligent and leads to a loss by the client, we have a PIS insurance of 10 million and the top-up insurance of additional $10 million. Now, if it's negligence, then it's not criminal. Now, in the management mechanism of that firm, there might be a problem in that mechanism. Now, so it's not just one partner who bears all the liability. Maybe he handled that case, but there's something wrong with that mechanism. Maybe it's the negligence of the whole law firm. In one case, that partner may be solely responsible. In another case, there may be assistant lawyers who are liable. Now, are you able to sort that out? Now, some lawyers, they just do it as a job, and they follow the instructions, and then the negligence occurs. Then it's not that individual lawyer who bears the responsibility, right? You are right. Now, if it's an employed assistant solicitor or a silent partner, then there's a vicarious liability. Then we will follow the PIS mechanism. So, but don't forget, we are talking about LLP. These are the partners. Yes, among the partners. So the assistant solicitor and the consultant for the law firm as a whole, that would be talking, here we were talking about vicarious liability of the firm as a whole. So if we pass this bill, then it will be at the final stage. You say that this final stage is a bit different from what it was initially. Now, can you tell us what's the difference? Are we giving you more than half, taking you more than halfway to what you want? Now, I've sat in this committee for almost over 10 years, so I have some certain feelings about this. Please be brief. Now, we dream of certain things, but in reality, some things cannot be achieved. Now, there are constraints. There's DOJ, the Consumer Society, and then we come to LegCo. The members have to consider public interest. So the LLP model that we now come up with, now, to the standards in my mind, we are maybe only 5 out of 10, if 10 is full marks. But we have to accept the reality. The Principal Amendment Ordinance was already passed in 2012, and it's now 3 years. So you can see that the progress has been quite slow. So, and we have to consider the subsidiary legislation, and which also have to be passed. So I hope that the LegCo members can also make things more convenient so that we can commence on the 1st of January next year.
LLP.
Well, that's the wish of many law firms. In the U.S., they started to have this in 1990s, and we are just getting it 20-odd years later. So we're just doing the catch-up with more modern systems in other jurisdictions. If members have no further questions, I think we can proceed to the cross-by-cross examination. It's CP4 1268 1415 bracket 02. Anything from our legal advisor? No? Well, I have no special question about the marked up copy. What do you say, members? Do you need to go over the crosses? Well, if members want to, by all means. Yeah, I've read it. Mr. Tony Chair, just one point. 73 capital A of LPO has been amended.
Carrying out of Section 78 capital D. 我想了解下嗰啲
I think this is an empowering provision to give flexibility to the law society. At this stage, do you have any initial thinking about the so-called (7AD)? Any similar provisions? Any initial thoughts? The limited liability partnership top-up insurance rules are made based on the section you have just quoted. So it's 73A, and now we have 73AD, and that's why we have these rules before us. Please refer to Annexure 2 of the LegCo brief. Annexure 2 refers to the top-up insurance rules, limited liability partnership. It refers to Section 7AD. So this is made, the rules are made under Section 7AD of the Amendment Ordinance. So, in the future, when LLPs take out top-up insurance, they have to do it through authorized insurance companies in Hong Kong, or Lloyd's in the UK, or Association of Underwriters approved by the Insurance Authority. So 3 sources. In the UK, there were problems. They took out professional indemnity insurance, and the underwriter was a foreign register company. And then when the claims were made, the insurer was found to be insolvent. So such policies that we require for LLPs must be Hong Kong registered insurance companies, or lawyers, or the other insurance associations approved by the Insurance Authority. This is for the purpose of consumer protection. I think it's similar to insurance for non-LLP law firms. I think they're similar, right? Insurance for LP firms and non-LP firms. I think you are talking about foreign law firms, local firms. We have the PIS for local firms, PIS. So a lawyer or law firm will have to contribute annually. Sorry, I was talking about the top-up insurance. Also, it's the same treatment, whether it's local firm or foreign firm. It's the same. There's the level playing field. We don't discriminate against foreign law firms, nor do we going to discriminate against local firms. Ms. Priscilla Leung, I have no further comments to make. I think it's the right time to move on. I just want to make one point. Well, the public may not know a lot about LLP. They see it in the name of the firm. So please do some publicity after this is introduced. You know, so that the public will know that there are two types of firms, so that they can make an informed choice. Well, that's very correct. When we were waiting outside, we discussed how the public education and publicity could be carried out. That's why we would like to see this implemented on the 1st of January 2016, so that we have a few months to do some publicity, to inform the public, and also to tell our own members that this option of LLP will be available, and also the requirement on top-up insurance. So rest assured that we are going to do this. You may take your summer recess, but our secretariat will continue to work hard in the summer vacation. Actually, we are not taking a vacation, although we adjourn during the summer. If members have no further questions, I'd like the clerk to advise us of the timetable. If the scrutiny is completed today, then there will be a written report to the House Committee on the 9th of October. What next? The scrutiny period has already been extended to the first council meeting in the next legislative year. So after submitting the written report to the House Committee, members may propose amendments by giving 5 working days notice, if any amendment is proposed. In other words, on the 14th of October, this is expected to be the end of the process. So I believe it's okay to have it implemented, to have the new LLP system up and running on the 1st of January. Any other questions? If not, meeting's adjourned. Thank you all for coming.